two last names, then he is on the docket.
And I'm sure Paul was great, but
Okay, so that's the closest I have to Sarah. Other than that. Oh, you know what he's got.
Now, we can change it if
Oh, that is attorney. Terrance needs an interpreter.
Yeah, do that.
Oh, that's your brother.
Yes.
Oh,
Okay, so he knows.
Yeah, yeah,
We
yeah.
can't blame him on here.
It's Cordero.
Yes, Your Honor. Ryan Morrow from Mr. Donald Frazier. I had reached out. My phone call went unanswered. Unfortunately, his voicemail box was full, so I was not able to leave a message. I instructed my legal assistant that if he returns the call, I'll raise the court of the situation. But at this moment, I don't have any more information for the court.
State.
The same request can give us.
People issue a no bond case. Mr. Medina, you want to do branch?
Yes, Your Honor, we are ready. The state's ready to proceed, and we just need to bring them out here, and I'll give them the news.
Okay.
Which one are we doing? William Branch, B-R-A-N-C-H. We're ready for
William
you.
Branch.
We've been over the agreement, Your Honor, they just need to sign.
Okay.
The state has its portion. Under Steve Medina with William Marcus Branch in 22 CF 2390, 22 CF 2397, and 22 CF 2412. Mr. Branch was held over to the afternoon docket. He's signing his agreement. The state has had appropriate outreach to alleged victims, and so we're ready to do the deal. And I've been over the score sheet. This, do you need to reprint it?
I'm gonna have to read this.
Your Honor, we've been over the score in detail, and I don't have any questions. We're not questioning the state score sheet. If I may approach with the agreement, Your Honor.
And Your Honor, just so you know, the score sheet shows a presumptive prison sentence of 93.15 months, which is what Mr. Branch is claiming to do this afternoon.
Thank you, Your Honor.
When you say presumptive, you're talking about minimum guidelines?
Correct, Your Honor.
And Your Honor, this doesn't involve probation, so I'm not going to burden probation with a copy, but I am giving Mr. Branch, you already had a copy, didn't you? Yes, sir. Oh, good. All right, may I proceed, Your Honor? Thank you. Your Honor, under this plea and sentence agreement, there will be a change of plea to no low contendere in exchange for an adjudication of guilt as charged. It would be a concurrent 93.15 months DOC with credit for all time served. The state is also asking to reserve jurisdiction for 180 days in each case for restitution, $967 in court costs times 2 for 22 CF 2390 and 22 CF 2412. There would be $515 in court costs in the third case, which is 22 CF 2397, a total of $350 public defender fees. And he is asking that the monetary obligations go to collections or lien as appropriate as soon as possible. Of course, with respect to the restitution, he understands the court's reserved jurisdiction for 180 days. He's going to prison for a long time. He doesn't anticipate any ability to pay, and I think it'll be reasonable for them to go to collections or lien if we could have that reflected in the record.
I would agree.
Thank you.
You want to put that in?
Yes, Your Honor.
I was going to ask you about that. Thank you.
And the only other question mark, Your Honor, is that with respect to 180 days reserved on restitution, he would like to go ahead and proceed to DOC. Hopefully, he wouldn't be held up in Okaloosa County Jail. And could the record reflect that he can go to DOC without being held back?
I don't have any issues with that.
For instance,
does the state know what the
Your Honor,
protocol is for that?
I do not, but I can try to find out, Your Honor, just to let the court know. I'm not anticipating any restitution from the victims. I haven't received the form, and when I talked to them about that topic, I don't think anybody was saying that they were owed any monies. I will make sure of that and let Mr. Medina know. And if it's possible, we could, if we need to have a hearing, we can maybe set up a Zoom or something. The state absolutely doesn't object to that.
And it gets him out of the Okaloosa County Jail for the taxpayers.
I was, my only question was, I don't think that just having the potential for restitution would hold it, but sometimes there are rules that, surprise even us.
Yes, Your Honor, and because in abundance of caution, he understands that no matter what, he wishes to go ahead and conclude the agreement today. Thank you. So I've added monetary obligations to collections or lien, period.
And Branch, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide in support of the truth, nothing but the truth, so help you?
Yes,
Okay, Mr. Branch, you heard your attorney state the terms of the obligation, the terms of the plea agreement, and those same terms are contained in the plea and sentence agreement which you have signed. My first question is, have you read this plea agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney just to make sure you had all your legal questions answered?
Yes, sir.
And importantly, you understand that by entering into this plea agreement here today, you're waiving some valuable legal rights, which is, the main one is the right to contest this, the right to go to a trial, force the state to prove their case beyond a reasonable doubt. That's all going away so that you can have the final resolution of this, which is what's occurring today. Do you understand that?
Yes, sir. I do.
And you believe that's in your best interest to do that?
Yes, sir. I do.
Nobody threatened to coerce you to get you to enter into this or promised you anything that's not in this agreement?
No, sir. I do.
Do you have any further questions regarding this agreement?
No, sir. I do.
Very good. Based upon that testimony, the court will accept your plea agreement. There will be an adjudication of guilt as charged. And the court will order the defendant sentenced to 93.15 months in the Department of Corrections for each of the 3 charges. They will all be served concurrent. They'll be served at the same time. You will get credit for all time served, and the jurisdiction is reserved for 180 days in each case for restitution. And just so you understand, I think it's been explained to you, but if the state does file something, you'll have the right to object to it, and have an attorney in file it. Then you'll have the fees and costs that are listed in the plea agreement, and these monetary obligations will go to collections easily.
Yes, sir.
And you do have 30 days, even though we're entering into this agreement, you do have 30 days to appeal this. Okay?
Yes, sir.
Okay. Any questions?
No, sir.
Your Honor, before we end the hearing, can I just put on the record that I did contact all victims on all cases, notified them of even with short notice, that he was going to take a plea today. They understand this plea. I went over this plea with them, Your Honor. Everyone agreed. We spent a good amount of time re-examining prior offers and going over the pros and cons of taking this guideline sentence offer. Everyone agreed that it was in their best interest to go ahead and let Mr. Branch plead to the guidelines sentence and go ahead and get these matters resolved and secure a plea as charged, Your Honor.
Thank you, sir.
Thank you, Your Honor.
Did you want Bowman next?
I do need a moment with Mr. Bowman, because I just sent that the agreement for his evaluation, sir.
Okay.
So that would be the only other one for this morning, I think, for me.
Yes, sir.
Thank you.
So let's go ahead and proceed with our felony plea docket. So we'll begin, Mr. Medina, if we want to do yours.
I would love that, Your Honor, so I can then talk to some inmates. I have 3 that are out of custody ready to be called, if I may, Your Honor.
You may.
Thank you. First is D'Angelo S. Armstrong. Your Honor, Mr. Armstrong is approaching in 23 CF 1341. He would enter a plea of not guilty and ask to remain on the August 14 docket.
Very good. The court will enter a not guilty plea and continue this to the next pretrial, August 14th at 9 a.m.
Your Honor, and I gave him my card with my assistant's name on it. If he could also make sure he completes the public, okay, well, I will. If he needs to complete the public defender application to be formally appointed through the clerk's office. So you can do that on the first floor before you leave the courthouse, okay? I'll give him my card, Your Honor.
Thank you.
Does he have an application or anything?
He has it, sir. First assistant's name, so you'll call her to make an appointment. Okay, thank you. Your Honor, next is Mr. Ariel O. Barrios. Mr. Barrios, he met with me and had a very productive meeting, but he's probably not eligible for the public defender. He hadn't completed his application. He's told me he's getting a private lawyer, which I understood he was going to be working on. I do think for purposes of today, I can enter the plea of not guilty for him provisionally, even though he's not filled out the application with the public defender. If he is going to keep the public defender, he'll need to get approved, but I don't think he would get approved based on his income. And if he could just remain on August 14, and you need to get a private lawyer working on the case before then, okay? So, thank you.
Any questions? We'll enter a not guilty plea and we'll come back August 14th at 9 a.m.
Thank you.
Good luck. Your Honor, next is Charles A. Brush. Mr. Brush is approaching in 23 CF 1360. And, Your Honor, for purposes of today, Mr. Brush will be entering a plea of not guilty.
I understand. On my document, it says there's not been an attorney. I just want to make sure that the PD has been appointed.
My information was that we had, but I may have bad information.
If not, we will.
He told me that he filled out the application, and it looks like I have the sticker that my assistant gives me if he's been approved.
Yes, sir, he was just given the public defender yesterday.
Very good.
Your Honor, so we would go ahead and enter the plea of not guilty. I would note a couple things is he's informed me he may be getting a private lawyer. If his next court date is August 14, that probably seems appropriate. You'll need to get on getting a private lawyer right away if that's what you're going to do, okay? But meanwhile, Your Honor, there was one other matter that we may or may not be able to address today. He informs me that his conditions of pretrial release said that he needed to remain local, or at least was it in the state of Florida or in Okaloosa County? Do you know?
No, sir.
I'm not sure where that arises from. I'm looking at Mr. Brush's June 19, 2023 paperwork. I didn't see anything about that, but I'm just trying to get it clarified because he represents to me that he lives in North Carolina. That's what's stated on his application for the public defender. And he just wanted to make it clear, is he able to leave the state and go back home and go back to work or not? That's the question. Does the state see any limitations in that regard?
Your Honor, just so you know, I received an email from Mr. Warner he's an assistant attorney general at the fraud unit there. He actually is
Fraud
taking,
unit where?
he's the office of the attorney general.
Okay.
He is actually prosecuting this case, but he had a matter in another county, so he emailed me and asked me to cover this hearing for him. He was expecting the defendant to enter a plea of not guilty this morning. I am looking, I just want the court to be aware that our office will not be handling it, that the fraud unit of the Attorney General's office will be handling this, but I see on the judge's first appearance paperwork that it has the bond amount, no contact with victims or witnesses, no contacts with the elderly or disabled, and it has no contact with the victim or witnesses listed again. And it has pretrial services level B circled. That's what I can tell you that I can.
Your Honor, I would state on the record, may I just to interject, since I already interrupted, I apologize. But I would say that, Your Honor, in abundance of caution, he should immediately reach out to pretrial services and confirm whether they know of any standard pretrial service condition that's not specifically listed in your paperwork, because we don't want you to get in trouble. I don't think the court has any information that Ms. Sharpless doesn't have at this point in time, nor do I. But in abundance of caution, I'm just stating on the record, please talk to your pretrial service officer to confirm that, unless the court has any other direction.
No,
That's the only
I think
thing.
it's very good advice.
Okay.
And Your Honor, I will also let Mr. Warner know this came up, so that if it comes up again when this case comes on the docket, that he'll know and he'll be able to do some research into that issue, maybe call pretrial services and talk to them.
And I'm also making Mr. Brush fully aware that just because you have a case just because you live out of state and may or may not be allowed by your pretrial release conditions to go out of state, doesn't mean you don't have to go to court as scheduled every time. Thank you.
Okay. Any questions?
Your Honor, this is going to be scheduled for August 14th, is that the
Correct.
date?
August 14th at 9 a.m. and the court will accept the not guilty plea.
And just for the record, if the court will excuse the short pants, he won't wear short pants anymore either. Thank you.
Appreciate it.
Those are my 3 out of custody at the moment, Your Honor, if I may speak to some inmates.
Okay.
Thank you.
Ms. Graham, you want to try and do yours? I can see your, I did not come forward now that I saw your name here. I was going to go first.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Trisha Graham on behalf of Crystal Canizaro, case 23 CF 1123. I've spoken to the state. Information has not yet been filed. We're able to approach.
Yes, Your Honor, we can approach. Ms. Bergman was covering for Ms. Basso, but she had to step out, so I do have information from her.
And Dixie is AV preeminent rated. Dixie Dan Paul works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaysTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdun Boulevard in Crestview.
Judge, I have one out of custody issue.
Okay, go ahead.
Trayvon Harris, Charles Russell Public Defender's Office. This judge, this is Trayvon Harris approaching 23 CF 1366. State has filed an information. We have a copy. At this time, we're going to enter a plea of not guilty, request trial by jury in 15 days to file pre-round motions.
Very good. We'll come back on a regular pretrial August 14th at 9 a.m. Enter not guilty today.
Thank you, Judge. That's my only out of custody.
Okay, we've got a couple that don't have attorneys. Let's see if they're here. Danielle Goodson. State.
Your Honor, that is Ms. Boswell's case as well. Give me just a second to do out notes for her cases. Your Honor, the state has filed an information in this case, and Ms. Bosso was expecting her to enter plea conflict, but I don't see an information voting. Your Honor, the state will ask for failure to, a case for failure to appear.
Court will issue a no bond case for Ms. Goodson. Is Ahmad Houston here? State.
There's no information on that. The paper I have says no information.
Your Honor, that is a few different justice charge. Mr. Losco went to grab something off of the printer. We could pass that one.
Okay.
He may have some information for the court about that.
Okay. Okay, you want to do some of the inmates?
Judge, I have a James Harden who's in the audience, says he does not have an attorney. I got information for a James Merle Harden, H-A-R-D-I-N.
Okay, hold on a second.
Yes, sir.
Correct? No attorney, you come forward, sir. Would the state announce this case? This is Harden, James Merle Harden.
Yes, Your Honor. Again, Taylor Sharpless for Ms. Bosso this afternoon. The state has charged in 23 CF 1371, lewd and lascivious molestation, victim under 12 years old. This is a 25-year minimum mandatory case, Your Honor.
So, Mr. Harden, you do have a right with this charge to have an attorney appointed? Are you wish to have an attorney appointed, or are you planning on hiring a private attorney?
Well, I don't qualify for a state attorney. I have notified for a private one. I have a meeting tomorrow, Your Honor.
Okay. Okay. So, what I'm going to do is I'm going to go ahead and enter a not guilty plea on your behalf. That will preserve your rights. We'll go ahead and schedule this for a regular pretrial, August 14th at 9 a.m. That's the regular pretrial cycle.
Yes, Your Honor.
So when you go in and talk with your attorney, bring that date and tell them that you're on that docket.
Yes, sir.
Okay?
Yes,
Any
sir.
questions? But
No, Your Honor.
even if you don't have an attorney, you need to be here on August 14th at 9 a.m.
I'll be here.
We have to deal with that.
I'll be here.
Thank you.
Thank you, Your Honor.
Thank you, Deputy.
Yes, sir.
You want to do any more, Mr. Gates? You want to do some of the inmates? Do we have the inmates?
We do. I was just going to put them out in order because I don't have who's belongs to who, so I was just going to go down the list.
Well, and Judge O'Mine that are in custody, they're looking for a plea hearing, so we wait on them to stay.
Okay.
And Mr. Medina's back there talking to his inmates too. I don't think they're prepared.
Okay.
Me.
Not yet, but they're not ready to be.
You're good.
So, just, well, let's proceed with some of the stuff, if we can, some of the shorter things on our motion docket. Mr. Stewart is here.
Good afternoon, Your Honor.
Hold on a second. On your case, I was a little unclear about
238.
what we were doing.
Yeah, it's gonna be a plea today.
Okay.
Make it so. Yes, sir.
It looked like there was a possible motion to continue, and I wasn't clear whether.
Yeah, the 230 are still being approved.
Mr. Gilbert, you want to try and do yours? Let's see.
Your Honor,
I know we're.
we got Mr. Bates as Ms. Sandler's case, and I was anticipating Ms. Sandler to be here for Mr. Bates, so if we can wait.
We'll hold off then. I'm just trying to move this thing along.
Did you want to take a recess, Sharon? I'll call you when Mr. Medina's ready. What's that? Is Darius absent?
It's with Mr. Medina.
Oh, he's.
Yeah.
We'll try and do yours first, just to make sure, grab Mr. D and tell him that.
We're going to church, the other one. And he's
You know, I can let
supposed
Mr. Medina know we're ready for him right now and get him back in here. You can see it, I mean, it's here.
See if we can move at least to the interpreters.
Hey, did you say when you can tell Mr. Medina we're ready for him, judge is ready for him? That'll give him a turn.
Oh, no.
I'm going to do, Lasco, are you aware of what's going on with the Mark Houston case, the fugitive, out-of-state fugitive?
One second.
Somebody said, your compadre there said that you were handling Mark Houston.
That's correct.
What's his name?
Oh, yeah, sure.
Yeah, keep working on. Sorry, man. No, you're ready. Madam Interpreter.
Buenas tardes, señor. Pablo, por aquí, por favor. Mi nombre es Teresa, yo le voy a servir de intérprete. Mira, señor, aquí. Mirando al puesto.
Your Honor, Steve Medina with Mr. Cordero Tercios, Cordero Tercios, and he should be 11 on the docket.
I've got it, thank you.
And his first name is, in Spanish pronounced Henry, but it's, or Henry or something.
Henry.
Thank you.
Henry.
But it's spelled Jenri. Your Honor, at this point in time, Mr. Cordero Tercios will enter a plea of not guilty. I have met with him at Okaloosa County Jail, and we'll be meeting him again with an interpreter in the near future once we get discovery, setting depositions and so forth. And at this point in time, if we could just keep him on the August 14 docket, I'm skeptical that we'll resolve the case that day, but we'll move the case along as much as we can.
How about August 16th?
August 16 is correct.
So the court will enter a not guilty plea on behalf of the defendant. We'll come back on August 16th at 9 a.m. Hopefully there'll be movement on the case.
Yes, Your Honor. Thank you.
Victoria Biru.
Dándole a Thank you, sir.
Thank you.
Yes,
Appreciate
sir.
your help. Thank you.
Judge, to go back to that Houston case, I don't have information for you right now, but I am working.
Thank you. Yes, Your Honor. Victoria Lynn Berube before the court in docket number 323 CF 1344. She also appeared last week in 23 CF 12.
Hold on a second. Let me get you.
I think it's
I got
docket
it.
3.
Got it. Thank you. I'm sorry. Go ahead.
Yes, Judge. She is before the court today in 23 CF 1344. She would enter a plea of not guilty in that case. We already entered a plea of not guilty last week in 23 CF 1222. She and I have discussed things. She has an 11 months, 29 days offer, at least. I'm not sure if it's intended to encompass both cases, but in the event she respectfully wants to me to work on the cases, and so she can come back August 16th.
Okay, so the court will enter a not guilty plea on behalf of the defendant. We'll come back August 16th at 9 a.m.
Thank you.
Thank you.
Derek Bowman. Your Honor, we have an agreement. Mr. Derek A. Bowman is before the court in 23 CF 1125, 23 CF 1410, and continued over from this morning, Madam Clerk, 21 CF 2718. And, Your Honor, we have been over an agreement that's been worked out with the state, and Mr. Bowman is signing the agreement that we've been over, Your Honor. And it is going to involve revoke and terminate, so I'm going to give probation a copy, Your Honor. And the state is, I believe, has a score sheet or
I do, Your Honor. Mr. Bowman scores 39.7.
big thing.
The defense is okay with that.
Just making sure he's seen it, Your Honor. Your Honor, if I may approach with a signed agreement and score sheet. We don't have any question on the score sheet.
Thank you.
Thank you. And Your Honor, I think I have an extra copy here, and if I may, Your Honor, under the agreement, Mr. Bowman is entering a nolo contendere plea on the two new law cases, which are 23 CF 1125 and 23 CF 1410. He was already adjudicated guilty in the 21 CF 2718 case, and the state is agreeing to dismiss count 3 and 23 CF 1125 in exchange for an adjudication of guilt as charged on counts 1, 2, and 4 in 23 CF 1125 and in 23 CF 1410, which had a single possession of controlled substance charge. He will be admitting the felony DOP. There will be a revoke and terminate on the existing supervision, which is probation. He will do 9 months concurrent Okaloosa County Jail with credit for all time served.
Is that on all the felony counts?
Yes, Your Honor, on all the felony counts and on any misdemeanor count that is being pled to, which I think the only misdemeanor counts would be 4 and 5. Excuse me. It looks like to me I have an error in omission on count 5. That's also being pled to, and I will need to take the copy back so I can put a caret and refer to count 5 because he's cleaning that out too. That was a misdemeanor. I'm sorry I missed that. You see what I'm saying? You're also cleaning out the resisting without violence misdemeanor too. I just missed that number. You see that change? Y'all see that? I apologize, Your Honor. So he will be admitting the felony BOP, revoke and terminate probation. It'll be 9 months concurrent Okaloosa County Jail, and that's concurrent across all cases and counts, with the exception of the misdemeanor BOP count in 21 CF 2718, which was count 1, which I'll refer to in a minute. And Madam Clerk, it's all set forth in writing here, so hopefully it'll be clear. There will be $615 in court costs times 2 in the 2 new law cases, $100 VOP fee and 21 CF 2718, a total of $350 public defender fees. Outstanding obligations, monetary obligations, will go to collections 12 months after release. And then, Your Honor, there's a lengthy paragraph that stipulates that basically the misdemeanor VOP part of 21 CF 2718, in essence, that probation would have expired a long time ago by operation of law. So I won't repeat that whole paragraph in the record unless I have to.
No, that's fine.
And I think that is the sum and substance of the agreement, Your Honor.
State,
That's the state's agreement, Your Honor.
Mr. Bowman, would you raise your right hand to you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement that you've signed. Have you read this plea agreement closely?
Yes.
And have you gone over it in detail with your attorney, make sure you had all your legal questions answered about this plea?
Yes.
You understand, importantly, you're waiving some valuable legal rights by entering into this plea. The big one is the right to go to a trial, force the state to prove their case.
Yes, sir.
We're waiving that, you're giving that right up so that we can have a final resolution of this case here today.
Yes, sir.
You believe that's in your best interest to do that?
Yes, sir.
And you're entering into this freely and voluntarily.
Yes, sir.
Any further questions you have of your attorney about this plea agreement in any way? Based upon that testimony, the court will accept your plea agreement, and the state's going to dismiss count 3 of 23 CF 1125, correct?
Yes, Your Honor, that's the state's agreement.
So the court will, there'll be an adjudication of guilt as charged on counts 1, 2, 4, and 5 in 23 CF 1125, and also 23 CF 1410. You also will admit the felony violation of probation, and on all these counts, the court will revoke and terminate probation and sentence you to 9 months in the Okaloosa County Jail. All these will be served concurrent, so all 9 months on each of them, but they'll all be served at the same time. So a total of 9 months. You will, of course, get credit for all time served. There's fees and costs that are contained in the plea agreement, and any outstanding monetary obligations go to collections 12 months after you're released from the jail. So, and the misdemeanor basically has expired, exceeded the statutory maximum. So you don't have to deal with that at this point.
On the misdemeanor BOP, Your Honor?
And what did I say?
You said misdemeanor, I just wanted to clarify what was on the misdemeanor.
Misdemeanor BOP 21 CF 271. Okay?
Thank you.
Any questions?
No, sir.
Thank you very much.
Did you tell them 30 days, Your Honor?
Sir, you do have 30 days to appeal this, even though you just agreed to it. You have to appeal, you can appeal it within the next 30 days.
That's what Mr. Bolo said.
Thank you.
Mr. Boyette would be next. Your Honor, Mr. Boyette, I was hoping we could set aside for a few minutes. I was in the middle of talking to him, and
That's fine.
so if he could go back and just reach out to the prosecutor on this.
Sure.
Thank you, Your Honor. You got the next
Brown, Larry Brown.
Brown.
Larry Brown. Mr. Medina, would you please announce the case? This is Larry Brown, Mr. Medina.
Oh, I'm sorry, Your Honor. Governor Steve Medina with Mr. Brown in 23 CF 1356. May I have a moment with Mr. Brown? I'm sorry, I didn't get to speak. Your Honor, at this time, Mr. Brown is going to enter a plea of not guilty. He has an 11 months, 29 days jail offer, which he is not interested in at this time. I would inquire, is there any way the state anticipates he could do a probation deal today? Because we might can set him aside if that's possible.
Not today, Mr.
Okay, so at this time, Your Honor, if he could remain on August 16, or put him, if you will, please, Your Honor, on the August 16 docket, and he will, we'll see if we can work out at that time.
Very good. The court will enter a not guilty plea on the defendant's behalf and come back August 16th at 9 a.m.
That's right. Thank you, Your Honor.
Terrance Cole.
Counsel, would you announce?
Thank you, Your Honor. Steve Medina with Terrance Cole in 23 CF 942. And I note for the record that Mr. Cole also has another case, 23 CF 1388, which is on the August 17 plea day docket. I think he'll just need to come back on August 17 if we haven't resolved the case. Cases by August 16 pre-trial and the 23 CF 940.
Has there been any information on that 23 CF 1388?
I think there has been, Your Honor. We might be able to go ahead and enter a plea of not guilty. If I'm not sure, Your Honor.
We're checking. Your Honor.
Yes, Your Honor, there hasn't been an information filed.
So we can enter a not guilty plea if we can waive arraignment and enter a not guilty plea in 21 CF 1388. We'll not have to come back on August 17 and put everything on. We can advance the pretrial on that one to August 16 as well, Your Honor.
Very good. So
And
we'll enter not guilty pleas on both the cases.
Yes, Your Honor.
Come back August 16th at 9 a.m.
Your Honor, I didn't get a chance to tell him, but I'm state worker, but I did work late last night on a motion to dismiss filed on his behalf in the first case. I'm going to give him a copy of that. And there was discussion this morning about whether that is appropriately noticed. I did not intend to mess things up with the court's docket, but I think it might have been put on August, was it August 17th? Madam Clerk, you were telling me that's what I did?
I'm sorry, I was getting the new case put on the minute sheet.
Okay, I'm sorry.
That's okay.
I just wanted to discuss scheduling for a moment, Your Honor, so we didn't have any mess up the court's motion hearings.
Yeah.
What would you like?
My question is, the motion to dismiss that we filed early this morning in 23 CF 942, is it set for, was it August 17 that we set it for? I didn't have the notice, with me. That's pre-trial.
Yes, Your Honor, it was placed on your August 17 at 2:30. That made it a total of 9.
For the court's for consideration, it's a motion to dismiss that would be legal. I think legal argument. I don't anticipate it would take more than 20 to 30 minutes to argue it. But if we have to push it off to another date, then so be it. I wasn't trying
It's
to.
on August 17th. We'll keep that.
Okay.
We're covered in there now.
Thank you, Your Honor. So we'll see the court on the 16th to see if we can resolve the cases at that time. Thank you.
Thank you.
Well, Darius Jackson?
Madam Clerk, did you say 1:30 on August 17th? 2:30, okay, thank you.
I'm sorry. Charles Russell, Public Defender's Office. Judge, this is Mr. Jackson. Case number is 23 CF 1354. If I could have just a moment.
The only 230 we have here, Your Honor, is Mr. Alloway. There's no
Judge, in Mr. Jackson's case, we've reached a plea agreement with the state in exchange for a plea of no contest as charged. On count one, it would be an adjudication of guilt, 36 months probation, waive cost of supervision. He would submit to a substance abuse evaluation and any recommended treatment. He would be subject to random urinalysis. He would pay court costs and $150 public defender fee, and he would obtain a job. On count two, which is a misdemeanor, it would be an adjudication of guilt and time served. And I have a score sheet if I may approach.
Stated in agreement?
That's correct, Your Honor.
That's okay with the score sheet.
Yes, Your Honor.
Okay, Mr. Jackson, would you please raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you put your hand up. You heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that, look on the back, that you signed. Have you read this closely?
Yes, sir.
And have you gone over it in detail with your attorney, make sure you had all your legal questions answered about this plea agreement?
Yes, sir.
You understand importantly that you're waiving some valuable legal rights, the right to go to a trial, force the state to prove their case, all that.
Yes, sir.
No, this will be a final adjudication of this case here today. You understand that?
Yes, sir.
You believe this is in your best interest?
Yes, sir.
And do you have any further questions of your attorney about this plea agreement?
No, sir.
Very good. Based upon that, the court will accept this plea agreement. And as to count two, there'll be an adjudication of guilt, credit for time served, and count one, which is a felony count, possession of controlled substance, there'll be an adjudication of guilt, 36 months probation. The court will waive cost of supervision. You must have substance abuse evaluation and recommended treatment, random urinalysis, and pay court costs, and obtain a job. Two things. One, I think we need to put in here that the evaluation has to be done in 30 days. That's what we've been doing, or 60, and then somewhere we have some, because it's a 36 month. If he doesn't do it until month 30, it doesn't help anyone, it doesn't help him. That's number one. And number two, it says obtain a job. I think we need to say, or make application, make good faith effort.
Judge, the only question I have about the 30-60 on the evaluation and treatment, I know that in the north end, probation has indicated. Yes, sir.
I don't have any problem with you making it 60-90 or whatever you believe. How long we get taking down in the south end to get substance abuse evaluations and start treatment?
It's been a number of weeks, Your Honor. Usually how we handle it is as long as they've made an attempt to schedule it and they can show us that they've obtained that appointment, we're good.
But it's usually within a couple months. Can you get the eval?
Usually it hasn't been even taken that long. It just depends on how long the waiting list is at the time.
in the 30-60?
We haven't had any trouble with anybody being advised because Bridgeway could have scheduled.
Mr. Russell, if you could put, maintain gainful employment or fill out 3 applications a week, I think that would be sufficient language.
One good thing is the job market's pretty solid. A lot of work to do now. Tell him he has 30 days to appeal.
Yes, 30 days to appeal. Mr. Kelly? Sir.
Charles Russell, Public Defender's Office. Justice, this is Robert Kelly, case number is 23 CF 1359, if I might have a moment.
Mr. Russell. Can I have a second?
Yeah.
Judge, in Mr. Kelly's case, we have reached an agreement with the state in exchange for a plea of no contest. The state's recommendation is adjudication of guilt, 90 days in the county jail with credit for any time served. He would pay court costs and $150 public defender fee. He would have 180 days after his release from jail to pay, or the money would go to collections, and I have a score sheet if I may approach.
Defense is okay with the score sheet?
No objection, Your Honor.
And the state is agreement.
That's correct, Your Honor. It's a adjudication with 90 days OCK.
Mr. Kelly, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? I do. So you heard your attorney state the terms of your plea agreement that are in writing in the written plea agreement, and that you've signed. Will you read this plea agreement closely?
Yes, sir.
You go over it in detail with your attorney, had all your questions answered.
I did, sir.
You understand by entering this, you're waiving the right to a trial, and this will be a final adjudication of this case.
Yes, sir.
And you believe this is in your best interest to enter into this?
Yes, sir.
Had all your legal questions answered by your attorney?
I have.
Based upon that, the court will accept your plea. There'll be an adjudication of guilt, and the defendant will be sentenced to 90 days in the county jail. You will get credit for all time served. Must pay court costs and fees. You'll have 180 days after release to pay, or it'll go to collections. You do have 30 days to appeal.
It's finished, Kelly.
30 days to appeal, okay?
Okay.
Thank you, sir.
That should have your arraignment document.
The only other one I have a Mr. Wallace, it's Mr. Parker, Rudy's case. Oh, you did? Okay. Good.
Judge, did you call Trayvon Harris?
Is that out of state?
No, Your Honor, that's the concealed firearm.
Mr. Harris is out of custody, Judge. I called him earlier, I didn't sure case. We entered a plea of not guilty.
Wonderful. And with regard to...
One at a time, sorry, I lost you. Which case?
Mr. Harris, it was 23 CF 1366, number 14 on the docket. Looks like it was called while I was gone, so that was taken care of.
Yep, and it was a not guilty plea, August 14th to 9 a.m.
Thank you. And Mr. Houston, who is the out-of-state fugitive, will be doing a no cross when back to the office. He has been transferred to Mississippi.
Very good, thank you. You get that, Madam Clerk?
Yes, he's going to put on your state to file no cause.
Very good. Okay, I think that does it for our plea docket. Plea docket.
Bryce Boyette.
That's right.
Boyette.
Right, Boyette.
Bryce Boyette, I'm working on an agreement to resolve one of his cases, and then the other one is being transferred to county court. We're going to work out a signature bond or something like that. So if I can...
just pass it on, just let us know.
Yes.
Thank you.
Like, you need him back today? We need to hold Mr. Bryce Boyette for a deal within the next 30 minutes or so.
We don't send Bryce Boyette downstairs. They are going to work out a deal.
Okay, we'll move to our 2:30 docket. I know we've got a few that are fairly quick. Mr. Stewart, I believe, was here first, so I'll let you go unless you enter a plea.
Yes, sir.
Bedner? Bedner.
We're in 33, Joseph Bedner.
May it please the court, Your Honor, Brad Stewart on behalf of Joseph Bedner III. Judge, this is 22 CF 2023. Mr. Bedner is in violation status, Judge, at this time. Mr. Bedner is prepared to admit the violation of probation. I do have a plea and sentencing agreement. If I may pause for a moment and show Mr. Bedner one matter. Your Honor, may I approach?
You may.
In your Honor, at this time, Mr. Bedner is prepared to tender an admission to the violation of probation with the understanding that this will be a modification of his probation to include 2 years of community control. That will be followed by the remainder of the balance on standard probation. The modification shall include no contact with the victim, her family, or her friends. There's a violation of probation fee, and he shall complete the original requirements. There's a requesting that the court waive the cost of supervision for at least the first 6 months, as Mr. Bedner has been incarcerated for 6 months? 4 months, I'm sorry, for the past 4 months, Your Honor.
Only point of clarification on here, I think it's important because it's terms of the probation that the no contact be clearly delineated who we're talking about, because just to be honest with you, everyone gets real uptight about contact when there's no contact. So we don't want it to be vague in the agreement. You have contact with somebody, you don't realize it, all of a sudden, you know, somebody's trying to hook you up. It's not, we're not trying to trick you. We want to make everybody clear, there's no contact and there's no contact. Can you, I don't know who the individuals are, we got to identify who the victims are.
There's a contemplation, yes, Your Honor. The contemplation is the known family and friends of the victim in this particular case, and those are
Justin Chandler, Dylan Chandler, Alice Yost, and Mrs. Scott. Mrs. Scott.
And Your Honor, for the record, those individuals are Justin Chandler, Dylan Elkins, E-L-K-I-N-S, Linda Scott, and Alice Yost. Your Honor, may I approach?
You may. Thank you. Do we have a score sheet?
Your Honor, there's a modification.
Your Honor.
Judge, we can submit it's a modification, Judge.
Defense is okay with it?
Yes, sir. I reviewed it.
And Your Honor, I don't think a score sheet's required for a modification, but in any event, he does score for prison.
Good point.
The state has spoken with the victim about this 2-year community control modification. And just for the record, we had a conversation about what would happen if we went through with the hearing and what might happen if the court found him guilty. And Department of Corrections and him not being on supervision versus us continuing to be able to supervise him for a number of years. The victim felt that him being supervised for a number of years was more in her interest than him simply possibly going to DOC for a little over 2 years and coming out on no supervision. So that is the reason for this downward departure, for the record.
Very good. Mr. Bedner, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes. So you heard your attorney state the terms of your plea agreement, and those same terms are contained in the written plea agreement that you signed. Have you read this plea agreement closely?
For sure.
And have you gone over it in detail with your attorney, make sure you had all your legal questions answered?
Yes.
And you understand that by entering into this plea agreement here today, you're waiving some valuable legal rights. Big one is the right to go to a trial, contest this, you get a good attorney, you can fight this. You're waiving that so you can get a final adjudication of this matter. You believe that's in your best interest?
Yes.
And you believe you have had all your legal questions answered?
Yes.
Very good. And you're entering into this freely and voluntarily?
Yes.
Very good. Based upon that, the court will accept your plea agreement. The court will reinstate and modify probation to include 2 years of community control, followed by the remainder of your probationary period on regular probations. There will be no contact with the victim's family or friends as specifically contained in the plea agreement. And then you must complete all the original requirements and have an additional $100 DOP fee. So the court will the court will waive cost of supervision. And you do have 30 days to appeal this file.
And Your Honor, also for the record, I know that Mr. Stewart and I had a conversation about it, but I think it's good to have this on the record that the state will not agree to any more modifications of Mr. Bednar's probation. And I have made a note for the files that if anyone else takes over this part of the division, there's a note on the file that the state will not be offering him any more modifications.
And it's important, one thing I always try and just, as a matter of clarity on this, is like I said, we're not trying to trick people. We actually want people to be successful on their probation. But understand that this no contact is one side. They could walk up to you in Walmart, want to shake your hand, or they can do that, but you're in violation. If they call you, you pick up the phone, you're in violation. Okay, so bottom line, we never have a problem with this, but the point is, if you run into them, figuratively speaking, someone, just walk away. If they come into a restaurant, walk away. You'll be fine. But, take it seriously. This is these no contact rules get on this type of charge. Everyone gets real, it's on edge on it. Okay?
Yes, Your Honor.
We want you to be successful.
Your Honor.
Yes, sir.
Where will the defendant be residing when he's released?
Thank you.
And are those supervision fees waived at arrearages and going forward?
No, I think it's just moving forward, Judge.
Just going forward. Mr. Bednar, the probation has asked where you intend, do you have an address where you'll be residing?
Yeah, it's the same one that's on file.
What is that?
6123 Confederate Drive, Pensacola, Florida.
Okay, very good. Thank you.
Your Honor, that's all I have, any issues? Thank you, Your Honor.
Is Chad Gray here?
Chad Gray?
So, who's handling that for the state?
I am, Your Honor. Judge, in this instance, he did.
This is a little bit of an unusual case.
I would agree.
Go ahead.
Judge, I believe that he explained previously at a hearing that he wanted to file a motion to dismiss. I don't think he ever did file that motion.
So I think on my notes, it said a motion to suppress. It was orally saying, or a motion to dismiss. And he was told in open court last time, go file it.
That's correct.
We set it for a hearing. He never filed it. He's not here. So it's not even been filed. So I'm not denying it because it's never been filed. So
yes, sir.
I assume he's up for his next hearing and we'll go from there.
When is the next hearing?
Good question.
What's the last name, please?
This is the Gray, Chad Gray, which is number 4 on the license. 23-430.
Yes, sir. I'm showing it's set for August 14th.
It's regular pre-trial. Thank you.
Is that today's hearing is canceled?
No, he just, his oral motion is, he never filed anything, so I don't know what we technically did today.
For the record, can I ask that the oral motion be denied?
Sure.
Thank you.
Because it was never followed, it wasn't followed. So, Mr. Gilbert, you're number one on the list. I'm not sure you'll be, yours is a lengthy one anyway, so why don't you?
Yes, Your Honor.
And then, Mr.
Luke. Thank you, Bill. Your Honor, Michael Gilbert on behalf of Christopher Bates in 20 CF 787. After the last pretrial conference.
Is Mr. Bates here?
No, I have it right on file. After the last pretrial conference, obviously this is an old case and it's a high interest item for the court. You're the third judge assigned to it, and Ms. Sandler is actually the fourth or fifth state attorney. And I'm up here asking for a continuance, and I just feel like we're owed a little better answers to the history of the case. We can get the court updated as to what has happened in the past roughly and where we're at as far as our preparation to move forward. This case started, it's obviously a 20 case. Judge Kristen Drake was the first prosecutor on it, and then we had COVID hit, and that cost us about a year. We had to go in for JAC funding for our experts. We had 2 in-court hearings on that, and then there's been several key personnel changes with state. However, since then, Sam and I have met, and we've had multiple conversations and email exchanges, and what I've been promised is an offer. If they're going to be able to give us one, will be coming forth in the next week or so. We're also going to edit down the witness list. It currently is at 40, as I related the other day, but we were talking about it, and it seems that we're going to be able to get down to about 20 state witnesses. And we're actively setting depots. We talked about the 29th and 30th, but now I'm seeing maybe the 23rd will also, or may work.
So we still haven't had depositions of their witnesses?
Correct, we have not.
Right.
So, what we anticipate the following reasonable period after depositions that we could resolve the case or get it set for trial.
And counsel for the state, is there been, you guys have been waiting, you all have been waiting to give a formal offer, there's not an offer on the table?
There's not a formal offer on the table besides a plea to the bench at this point in time, Your Honor. I'm working with my supervision to see if there's a reasonable offer we can extend. The defense did extend an offer that we rejected. So we are in good faith negotiations right now, and we have sent the defense a date for a full day of depositions. Obviously, we can't decide who the defense is going to depose, but we are giving them a full day for depositions. We do anticipate being ready for trial as soon as depositions are completed.
What would be your best guesstimate at that, when that's going to be?
I think we talked about the 29th and 30th of, excuse me, Judge?
This where the trial or the depositions?
For the depositions, Your Honor.
I'm looking for the big enchilada.
The big enchilada? If we do.
What are we targeting as far as you guys are both working this case hard? What do you see as?
October, November.
I would agree.
Well, let me just say this to you. You need to stay on this one. You know why? Because January 1st, you're going to have a new judge. And I don't want to, let's not rotate judges again. I will not be able to keep this after January 1. They do not allow us when we rotate out. Not January 1 of this year, January 25. But are you talking about November of this year? going to trial?
Absolutely, Your Honor.
Oh,
I believe it.
I thought you meant the line next to you.
No, please don't give me a heart attack like that and tell me that you're leaving at the beginning of this year.
No, we got another 4 years. You gotta put up with me for at least another good year.
Judge, we just need reasonable time after the depositions to do our work and prepare.
Well, that's very reasonable. I would say that would be an aggressive schedule, after it not being aggressively scheduled for the last 3 years. Well, but that would be, I mean, when you're getting that many depositions, that's an aggressive schedule, because you gotta coordinate lawyers, and unfortunately, you gotta coordinate the witnesses too.
And several experts, and that's notional. I would just point out that, it took us, because of movement in Tallahassee, months to get to talk to an FDLE lab technician. So things could occur, but we're working this case hard. We get the depot set. We have time to prepare formally for trial, and I think that's about it. If everything goes smooth, that's a good time to.
And so his next hearing date is just our pre-trial?
Yes, sir, August 14th.
And if I could ask for a continuance to the cycle after that, since we have that.
I will grant that continuance without objection. However, when you come back the next cycle, you need to plan on having Mr. Bates here and here for all following hearings. I want him to be involved. I want him, going up there, something adverse happens to him, he's going somewhere saying, I never talked to my attorney. I don't want those. I don't want him to hear it in open court, from the court or from the state or from you, we're going to all be, we need to start making sure he's aware of all that's going on.
No problem.
Okay, appreciate it. Thank you for giving us an update.
Thank you.
And Madam Clerk, what would that pretrial date be?
October 9th at 9.
Thank you.
Thank you.
Okay, thank you. Okay. Come on, Mr. Ray.
Good afternoon, Judge. I'll make sure there wasn't something else to go before me.
Well, I know, I wasn't.
No,
You were here first, so.
Judge, I've got Monday afternoon docket Nicole Bolo. She's an inmate. And for the record, David Ritter, she is 22 CF 1215 and 22 CF 2085, a BOP case, here for a long consideration. Your Honor, not to reiterate too much before we send the motion. However, she's before the court for a misdemeanor BOP for a DUI charge. The new allegation is a felony DUI allegation for an actual physical control affidavit basis.
I'm sorry, say that again?
The new charge is a felony DUI predicated on, misdemeanor DUI and felony battery on Leo for, I guess, resisting allegations from the car. The basic allegations that we got in the motion taken from the affidavit is that she was in her car in the parking lot of her place of employment. She worked at the Gulf restaurant on Okaloosa Island. That evening, she had just finished a shift around 10:45 p.m. At the time, and currently her license is suspended, so instead of driving to and from work, she commuted with a coworker not sharing a car. She was waiting on her coworker to exit prior to the evening. In addition to her factual circumstances, she still has offers of employment at 2 local businesses, one of whom helped her to retain counsel to try to get her back to work at that business. One is here in Walton Beach, one is over in San Jose County. She has a 7-year-old daughter. Her name is Michaela. Ms. Bolo is the primary caregiver for her daughter. And since the arrest, her daughter, I believe, has been in the care of multiple family members pending Ms. Bolo's release. To come home and start taking care of her again. In light of the fact also that we're at this stage, we're about a month and a half in since the arrest, we have received 0 discovery from the state. We're not just missing videos, there are no reports, affidavits, or any discovery in our possession at this time. I would also note that we're more than 30 days out. The state has not filed an information in the new case. We are asking the court to consider a signature bond in the new case, $1,000 cash or professional in the BOP case. Given the nature of the allegation, As stated in the motion, there would be no concerns if the court, for its own concerns, would like to impose a scram monitor and pretrial services in the condition of any bond that's modified in the case.
So, Your Honor, the information is coming, the intake is done, it just has not been sent to Mr. Rear yet. The state is going to be filing this as a battery on a law enforcement officer. Is this going to be a felony DUI, third within 10 years? And the resisting an officer, Your Honor, she was on probation for a DUI when she is alleged in this new case to have picked up another DUI, which is a felony charge. She also, at that time, resisted the officer, punched them in the leg. The officers did note that while she was not actively driving the car, this is an actual physical possession DUI. She was in the car. The odor of alcohol was present. She was then taken to the police station where she refused to do a breathalyzer test, where the probable cause does notate that her emotions were ever changing. At one point, the officer states that she stated she would consent to a breath test, and then when she got back to the police station, she refused a breath test again. So the officer's notating the odor of alcohol was present in the ever-changing emotions, Your Honor. She is not entitled to a bond on the BOP, and the state believes that the bond asset in the new case is appropriate.
One last thing regarding the odor of alcohol, Your Honor. At the Gulf, she works in the bar area of the restaurant. She just finished a shift, or I think it was at least 12 hours or so. She got off at 10:45 p.m. that night, and at the time, her friend, who was the driver for her, and her general manager were there in the parking lot. She wasn't getting drunk on the job. She smells like she works at the Gulf restaurant over there on the island.
So, just following inquiry, you may not know. Was the defendant sitting in the driver's seat or the passenger?
She was sitting in the driver's seat with the car in park and the AC running and the car with the music running.
That's my understanding, Your Honor.
With the emergency brake on.
Are there any conditions that the state would feel comfortable with as far as protecting the public, such as, obviously there's an offer of a scram?
Yes, Your Honor. First of all, the scram monitor, honestly, a prohibition on driving and a prohibition on alcohol at the very least.
Was that not already in place before?
I will check if it's not, it should be. Your Honor.
Do you know that on the prior law?
I do not see that noted, Your Honor, on the first appearance sheet. I see an interlineation of the bond amount. I don't see an indication that pretrial services should supervise her. I think the court should order that as well. The court's considering the bond.
And as stated in the bond, Judge, we would not object to pretrial supervision with scram. The obvious implication being no alcohol, because scram, the monitor on the ankle, will notify pretrial and the court if there is a consumption of alcohol during the bond period.
I'll grant the request. Signature bond on 12/15, $1,000 cash for professional on 2085, with the special pretrial condition of no alcohol and scram. Ma'am, I'm not going to order this, but I strongly recommend this.
Thank you, sir.
You need to get a different job. You need to get a job away from bars.
Thank you, sir.
Okay?
I agree.
Okay. Not good. I mean, anybody that's lived around this area has known people when they were kids, whatever, that worked in bars. I know what happens in bars. What happens in bars is there are a lot of legal and illegal substances that are consumed. That's what bars do. If you want to work there, if you've got an issue with that, and you want to stay around your child, you're going to go someplace, a restaurant maybe, that doesn't have a bar, or at least where you can stay away from the bar in the restaurant.
Yes, sir.
Good luck. We'll see what happens on your underlying cases. And if you come back again, if there's any further issues, you will not get any break. You're going to be staying until we get this a final resolution in this case.
Yes, sir. Thank you.
And Judge, I'll get a proposal where you can talk to the court this afternoon.
Very good. Make sure and pass it by.
I'm sorry, Judge.
Pass it by the state.
Will do, Judge. That's all I have. Can I be excused?
Thank you.
Do you want this thing attached before we release, or is it something that they'll work out?
Do we need to put in the order, counsel, do we need to put in the order that the scram is attached before she's released?
Yes, please.
I'll include the language. I think they do that as a default, no matter what
Yes.
the court release, they have to hook it up, but I'll include the language.
Okay.
Who do we want to do next? We got Alloway or King?
Judge, just so you're aware, Mr. King, I believe, we're going to ask to do a sentencing hearing. Mr. King's case as opposed to a final hearing. You're not sure if that affects the order in which you want to take anything.
Who is the, so these are all Mr. Morrow's cases. Which one do you want to do first, Mr. Morrow? I'll let you decide.
In the interest of getting probation out of here, can we handle Ms. King's case, or Mr. King's case, Your Honor?
Sure.
You can have 20 minutes.
Has there been anything filed in King's case by way of?
No, Your Honor. I spoke with Mr. King yesterday and then again the day before court proceeded to let him know that the witness was here, and gave my advice. So we asserted the desire to enter plea to the bench. I think his decision to go to contested hearing had less to do with his desire to challenge the allegations and more to do with the state's offer. But at the end of the day, I think Mr. King just wants to ask the court to consider time served and not go through the contested hearing based on the evidence and the weights. And
So is there a plea to the bench, or you guys?
he has it here in his hand, and I sent it back for him.
And you want to go to the sentencing right away?
And we can.
You're going to argue, we can argue?
Well, we have the probation officer here. If Mr. Losco would like to take testimony, I have Mr. King here if he would like to provide any, but we don't have to do it today, Your Honor. We just have the necessary parties if the court would like to, based on what we've passing things clear as September. I don't see the need for that in this case. We're only here on misdemeanors.
What? Okay, we'll proceed.
You wouldn't do it again. But I mean, she did accuse me of changing my residence, and I didn't. And there was a probation agent there that night, and I did it for myself. I think it's going to happen.
This is Mr. Larry King, Your Honor, 22 CF 2554. We were initially set for an evidentiary hearing. Mr. King would like to enter a plea to the bench. The state's offer was 1129. He faces an absolute legal maximum of 2 years in the county jail based on 2 first-degree misdemeanors. He was previously adjudicated of those underlying charges. I'll let Mr. King sign the written plea, rights acknowledgement.
King, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? I do. So, you heard your attorney state the terms of the plea agreement, the plea to the bench.
Yes, sir.
You understand what a plea to the bench is?
Yes, sir.
What is it?
I'm guilty.
So you're admitting to the charges, and you're can argue over the sentence. Okay? You understand that?
Yes.
You understand that by doing that, though, there's to be a final resolution today. Even if you may or may not like the ultimate end result, but you're agreeing to go forward today and go to the sentencing. You obviously have the restrictions. There's a maximum sentence of 2 years in the county jail. And force anything up to, down to zero. So you understand that, you believe that's in your best interest to enter into this kind of plea like this?
Yes, sir.
Why do you want to enter into this plea to the bench?
Because I'm not gonna put up with it.
What do you mean you're not going to put up?
Well, first of all, she lied and said I changed my place of residence where I was sleeping. I did not. It was a temporary.
Why don't you fight this? And rather than, why don't you force them to have testimony, get up on the stand, swear to it under oath that it didn't happen, and say it didn't happen?
Well, I'm not gonna fight.
You're not going to fight?
No.
You don't believe it's in your best interest to fight? So you believe something's true, but you just don't believe it's in your best interest to pursue that?
No.
But you have had all your legal questions answered of your attorney?
Yes, sir.
Based on that, the court accepts your plea, no contest. Adjudication of guilt, or, admission of the violations. Okay? Hold on a second.
I don't think they're gonna have any.
Do you wish to put on any testimony or evidence?
No testimony from the defense, Your Honor. I don't know if the state wishes to call it Plea.
Yes, Judge, I would like to call the officer who wrote the report.
Okay.
So her name is Officer Amberly Browner.
Ms. Brown, would you come forward?
At the top, if you remain standing, face the clerk and raise your right hand.
Clerk, would you swear the witness?
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please proceed. Mr. Morrow, Mr.
Thank you. Please state your name for the record.
My name is Amber Browner.
Officer Browner, how are you employed?
I am employed with the Florida Department of Corrections
How long have you been employed that way?
since April 16 of 21.
What do you do for the Florida Department of Corrections?
I'm a probation officer.
And what does that entail? What are your duties?
My job is to make sure that the offenders that are on my caseload, that they're in compliance with their court order conditions, also to assist them with resources and referrals to help them successfully complete their supervision.
And was Larry King one of those probationers?
Yes, he was.
How did he do on probation?
You said, how did he do on probation?
Yes, ma'am.
In office, I only had contact with him once, and it was a struggle to get him to come into the office to report.
Yes, ma'am. Let me back up. When was he placed on probation?
He was placed on probation November 15th of 22.
Okay, and what were the terms of his probation?
For Okaloosa, he had 24 hours of community service. He could have no contact with the victim, and he was barred from the premises of the victim's place of work.
Was he also going to be having a check-in with you?
Yes, he was instructed when he did report for intake that he would have to check in once a month to the probation office.
Okay. And when he was instructed, did he understand all of this? What was expected of him?
Yes, because he signed a temporary probation order.
Did he fail to report in January?
He did. I made contact with him, not in the probation office, January 31st, but it was not, he did not report to the probation office in January.
And what conversation did you have with him on January 31st?
When I did make contact with him at the First Methodist Church on 1st Street in Fort Walton, I instructed him that he needed to report the next day, that he did not report for the month, and why was he not reporting. I did tell him that the probation office was a mile away because I tracked it, and that he was supposed to report the next day by 4 p.m.
Okay. And did he?
No.
Did he report at all in February?
No, sir.
Well, how about April?
No, sir.
Okay. Did he report in March?
No, sir.
Okay. What steps did you take when you realized that he wasn't reporting?
The first step I took was I tried to make contact with him at the First Methodist Church again. The first step was December 28th of 22. He was not there, so that was the first. He reported to me. I first instructed him. I instructed him December 22nd of 22. So a few days later, December 28th, I tried to make contact with him at the First Methodist Church, where he listed was his place of residence. I was not able to make contact with him there. Then I made contact, on January 11th, I tried to contact his father and another relative that he listed on his intake paperwork. Both of their numbers were disconnected. On the same day, January 11th, I contacted Labor Finder, where he listed as his employer. They stated he didn't work for them for a long time. Then January 25th, I contacted the First Methodist Church, because that's where he listed as his, where he was staying. And I did make contact with the person that oversees the First Methodist Church and the people that stay there. And he told me that he does sleep on the porch there at night. Then the date I stated that I did make contact with him, that was January 31st, that I was able to make contact, and then I instructed him to report to the office the next day, which he then did not. Then February 11th, another officer told me that she made contact with her offender at One Hopeful Place and stated anyone on probation to come forward. She stated that the Mr. King came forward and said, "I belong to Officer Browner." Then on March 11th, I was told by another officer making contact at One Hopeful Place that was told to her that Larry King no longer resided at the One Hopeful Place shelter. On March 22nd of 23, getting the information from the other officers, I contacted the supervisor at One Hopeful Place and spoke to Miss Donna, and was stated that he has not been there since February, the previous month. April 12th of 23, I spoke back with the person that oversees the Methodist Church, Mr. Gary Hunter, and he confirmed that Mr. King was sleeping back on the porch of the church. On April 13th, I made contact with Mr. King. I went out to First Methodist Church after speaking with Mr. Gary to see if he did indeed go back there, and I made contact with him.
Okay, and when you made contact with him on the 13th of that month, what was that interaction like?
It was really brief. I had the orders, his certified orders from the judge, and I had his the offender financial agreement with me. Since I was unable to get him to come into the office, I wanted to instruct him on his certified order from the judge's signature. And when I got out of my car and I approached him and said, Mr. King, I have the orders with me, certified from the judge, an agreement I need you to sign, he stated to me, I ain't signing shit. Excuse my language. And then I instructed him, I said, I need you to report to the office today by 4 p.m. And quote, he said, I ain't coming nowhere. And that's when I got in my car and I left.
Okay. And did he ever complete his, well, first off, did he ever end up coming back to the probation office?
No, he never reported besides his initial. I told him it's not a violation to be homeless, but it is a violation not to follow his officer instructions.
I understand. And did he ever complete his community service hours?
No, he did not.
Okay. Do you believe that these are all willful violations?
I do.
Okay. And let me ask you this. Did he do anything for his probation as far as the terms of his probation?
No, he did not.
Okay. Do you believe that he's a good candidate for reinstatement?
No, I do not.
Okay. Why?
Because he made no attempt, no matter what I tried to say, do you need help? What can I help you with? I told him it's 1 mile away. If people can walk from the Okaloosa County Jail to report, then he can walk a mile to come into the office to report. No matter what I tried to do, he was just very rude. He said he can care less about probation. If probation wanted him, they can come and find him. And so I do not believe that him making himself unavailable for supervision and not following the conditions that was ordered for him by the court, that he's amenable to supervision for reinstatement.
Earlier, the defendant called you a liar. Is that reminiscent of how he's been treating you this whole time?
Yes, yes, sir.
Thank you. I have no further questions. I'll pass the witness.
No questions from the defense, Your Honor, just argued.
Thank you, ma'am.
And you may this witness be excused?
The witness excused?
No objection.
You may be excused. You're welcome to stay, and you're excused.
Thank you, Your Honor.
Thank you. So, any other witnesses?
No, Your Honor.
Counsel for the defense, you may make a
Thank you, Your Honor. The defense agrees that Mr. King is not a candidate for reinstatement or supervision, Your Honor. We're not asking the court to reinstate. We are just asking the court not to impose a jail sentence of 11.9. We're asking the court to consider imposing a county jail sentence of 6 months concurrent on both counts. These are both first-degree misdemeanor counts, Your Honor. He does have a fair amount of that credit, and that's what we're asking the court to consider doing today.
Judge, through testimony today, I think it's abundantly clear that these are willful violations. That's not in dispute at this time. But what I would like this court to lock in on is he has not done the very bare minimum. He's done nothing to complete his probation. And I think that that's important because you have somebody who isn't taking this seriously. He never took it seriously. When he was asked to walk a mile to get to the probation office, he said, I'm not going anywhere. When he was asked to sign some papers, he said, I'm not signing shit. Judge, this is an individual who never took the process seriously, and I believe that right now, 1129 is a fair offer or a fair resolution of this instance. I'm asking the court to impose 1129. Thank you.
The only thing that I might add, Your Honor, is Mr. King is indigent. Mr. King is homeless. He does not have transportation. I realize what they're suggesting about walking over, but I would suggest that he did have some difficulties, but I recognize everything the state's saying. We're just asking the court to consider to utilize its discretion and not impose the 1129 and consider a lesser sentence of 6 months consecutive on both counts.
Mr. King, based on the testimony and the absolute lack of cooperation on your part toward anything, the court really forces the court's hand. You were given probation to begin with on fairly serious theft charges, and you didn't even take any opportunity to try and correct that. The court sentenced you to 8 months in the county jail for each of the charges. They'll be served concurrently. You'll be credit for all time served. And whatever the standard fees and costs, you'll have 6 months after you get out to pay those if you can. Those costs. Okay. Anything else we need to do at this point?
Is probation terminated?
Probation is terminated. Yes, thank you.
Thank you, Your Honor.
Thank you.
I take it this is an adjudication, even though there was a prior adjudication.
You don't have to. Tomorrow? Who you wish to call next?
Alloway or Arden?
Your Honor, can we give Mr. Alloway first?
Alloway.
Miss Bergman is on her way back from Mr. Ard. She's covering Mr. Ard.
Okay.
In Your Honor, for the court's consideration, may I interrupt that? Bryce Boyette is ready for a plea whenever the court wishes.
Let's go ahead and do it. Let's do it.
And Bryce Boyette. We'll do Boyette.
His mother's here, working the way out shift at the Walton house, so she'll appreciate getting some sleep, I'm sure.
Is there any information coming on this, please?
I'm going to address the one that doesn't have any information. We're resolving the one that actually isn't on the docket, and then we're going to do a signature bond on the one that, let me try to. Yeah, I'll try to go over it when it gets up.
I didn't know there was any case on the document.
What's the name?
Your Honor, this is defendant Bryce Dakota Boyette, B-O-Y-E-T.
Okay.
Did you sign the agreement?
Okay, you'll just hold this copy and I'll let you sign the same identical copy the state's already signed.
Right.
That's not all here.
According to the school. Your Honor, we have an agreement that has been signed by all parties, if I may approach. Can I give the probation a copy for Mr. Boyer? And Your Honor, I'm approaching with 3 items, the plea and sentence agreement signed by all parties, the score sheet, and also a form order for business or employment purposes only, subject to the state statutes and BMV regulations. Thank you. Your Honor, under the agreement that's been reached with the state, what we're going to resolve is 23 CF 109. I'm not sure which one was on the docket, Madam Clerk, which one you have a minute sheet for.
23 CF 1362.
Right, well, my understanding is that in 23 CF 1362 is that the state is transferring that to county court. And after I address the agreement on 23 CF 109, we're going to be asking to cover the 23 CF 1362 with a signature bond so he can get out of jail today while that's being transferred down to county court. He'll have to address it in county court. Because the information hasn't been entered, we can't do a deal on that case. It would probably be a routine matter to also resolve it today, but we don't want to hold up a resolution in the other case.
Very good.
So, Madam Clerk, we're resolving 23 CF 109. I apologize for not giving you a heads up on that. Your Honor, under the agreement, 23 CF 109 would be adjudicated guilty as charged. There would be 18 months probation on count 1, which is a third-degree felony possession of controlled substance. 11 months, 29 days of concurrent probation on count 2, which was a paraphernalia misdemeanor. Substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days. Random urinalysis, 615 court costs, 150 PD fees, 6-month driver's license suspension, provided that there's no objection to entry of the form order for a business or employment purposes only license, which that's if qualified, and that's the form order that I've already handed to the court. And I don't think there are any other things to address with respect to 23 CF 109 other than the state and the court allowing the plea to be entered. But I do want to go ahead and address 23 CF 1362. As I've indicated, the state is represented to me. I didn't see it showing up in benchmark yet, but it apparently is being transferred to county court. So I believe the state would stipulate to convert the cash and professional bonds to a signature bond. It would be a total of a $4,000 signature bond.
That's correct, Your Honor. And the felony DWSR does not meet the requirements for the felony. It's a misdemeanor driving while license suspended.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backroom Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in his.
DCA apply.
Yeah, well, that's true.
There's conflicting in the first and
Yeah.
I'd like to reject all the second DCA cases sometimes. Okay, go ahead.
Your Honor, if the court will consider doing so, we are requesting a signature bond. There was on what is now going to be a misdemeanor, driving while license suspended, but at the time of first appearance was a felony, but the state's not actually going to charge it as a felony. And that was a $2,500 cash and professional, and then the paraphernalia will remain as a $1,000 cash and professional. We're asking to change them both to signature bonds.
Okay. State okay with that?
The state agrees with that.
So it would be a total of $4,000 signature bond.
Okay, very good. So, Mr. Boyette, would you raise your right hand? Swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
So you heard your attorney state the terms. You can put your hand up.
Yes, sir.
You heard your attorney state the terms of the plea agreement, and I see those same terms are contained in writing in the written agreement that you've signed.
Yes, sir.
So have you read this plea agreement closely?
All 4 pages.
And have you gone over it in detail with your attorney, make sure you had all your legal questions answered?
Absolutely.
And importantly, you understand you're waiving the right to go to a trial and contest, state to contest and everything. You want a final resolution, giving those rights up so you can get a final resolution.
Yes, sir.
Is that what you want to do here today?
Yes, sir.
You believe it's in your best interest to do that?
Yes, sir.
Very good. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt as charged on both charges. You'll be sentenced to 18 months probation in count 1, 11 months, 29 months probation as to count 2. The probation will be served concurrently. You must have a substance abuse evaluation within 30 days and follow any recommended treatment to commence within 60 days. You've got the court costs and fees that are contained in the plea agreement. And then you've got the 6-month mandatory driver's license suspension. And then the court is also signing the order for business or employment purposes only qualified.
Sir.
Okay. Very good.
Thank you, Your Honor.
Cancel the order.
Right this way, Mr. Good luck, Boyette. Ronald Alloway. Your Honor, I think the court needs to instruct him about 30 days for appeal, and also he needs to report by 8 p.m. tomorrow.
Mr. Boyette, you do have 30 days to appeal the ruling I just made. You got to make sure and get down there first thing in the morning. Probation, please. 8 a.m.
Thank you, Your Honor.
Thank you. Sure. Mr. Morrow.
Again, Your Honor, this is Mr. Ronald Alloway, 22 CF 1657. We're here for sentencing Mr. Alloway in the plea of the capital guidelines.
Mr. Morrow, please speak into that moment.
I'm sorry, Your Honor. Ryan Morrow for Ronald Alloway, 22 CF 1657. We're here for sentencing.
Okay. Do you wish to make any opening remarks, or just are you gonna?
Nothing outside. I submitted a very brief memorandum to the court outlining my position. We're asking the court to consider reinstating Mr. Alloway's probation, Your Honor. That would be my only opening statement. I'll take some testimony from Mr. Alloway at the appropriate time.
State wish to make an opening statement or just wait?
Your Honor, we'll wait.
Okay. Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Good morning, sir, or good afternoon now. Would you state your name, please spell your last name for the record?
Ronald Alloway, Alloway.
All right. And you're here today after having admitted your violation of probation. You're here for sentencing, you understand that?
Yes, sir.
And we've discussed all this at length, but just for close awareness, could you expound upon the circumstances surrounding the violation?
Well, at the time, I was having a baby, newborn, and complications with my relationship with my baby mother, and it kind of like stressed me out a little bit, and up and down relationship, and having a baby, then find out, DCF involved and everything.
And how was it that DCF came to be involved?
Well, at the birth, they said they tested the baby for cocaine or something in the system and stuff.
And now DCF has initiated a case plan, and that's something that you're going through?
Yes, I'm going through that, and matter of fact, I had a 9 o'clock DCF case this morning, and they implemented another joint adoption, because they said if I don't finish the case plan at a certain time or something, they just don't adopt it. Yeah.
And you're doing the best you can to work it from inside incarceration, but it's not very easily done.
Yeah, it's not. Yes, sir.
Okay. Do you have any other children?
Yes, I do.
And despite the history,
right now, I have a daughter, a 5-year-old, that my sister's looking at until, I solve this issue, because I have employment, I have a place to live, and, stuff like that I'm looking to lose, and 2 vehicles.
And before we get into all the good things that you have going, anything else that you would say surrounding the allegations of violation, what was going on around that time?
Just trying to maintain my family and everything, and be a father and stuff, and just going a lot of stress, fighting and bickering and stuff, which shouldn't be. I mean, I don't blame mostly me, and sometimes being hard-headed and stuff. And I ain't gonna say the pregnant women syndrome, but a lot of that too.
Understood. So getting back to the good things that you have going, are you currently employed?
Yes, I work at Wendy's at night, closing Wendy's on Racetrack in Fort Walton, and I do side jobs, small carpenter, construction, concrete, landscaping, whatever needs to be done to provide for my family.
And do you have reason to believe that job will still be available to you if you're released?
I do.
Okay.
Matter of fact, I talked to my employer the other day, and he was like, well, whenever you get out, just come and you got your job.
And to be clear, this is at Wendy's?
Yes, sir.
Okay. And we've discussed this again at the jail, but that's not really what you've been doing for most of your life, correct?
No, sir. I work for a company called Brasfield and Gordon for about 15 years doing shutdown work at nuclear power plants, and build a lot of nice condominiums. And I work for a company also called General Mason out of Alice Beach in 38, and I was foreman supervisor running those.
And why is it that you're not doing that anymore?
Because I'm in here.
Well,
besides that, I developed a little glaucoma in my right eye, and I went a couple weeks ago, and they were saying it's about lost. So now I'm down to minimizing my work at Wendy's and trying to, like I say, maintain the job and keep my family going.
And you do have a place to stay, correct?
I do.
And what would the address of that place be?
It would be 702 Woodlawn. Okay. It's on my ID.
Understood. And you got good transportation?
Yes, I do.
Okay. I also noticed you're wearing a wrist brace. Is there anything going on with your wrist?
Well, I have failed doing some work, and I fractured both my wrists, but I separated this week, and lately it got twisted, and it's like swollen and starting to deform. And I just need to get to a doctor. So I had x-rays up at the jail. They said I need to get to a doctor to see if there's any muscle tissue in it before I can lose it, because I've had it and close it and stuff.
And besides this violation that we're here before the court on, and the charge that got you put on probation, Can you tell us the last time you had a brush with the law prior to that?
It's been a while, maybe about 7, 8 years or 10 or more. And the last time that I think I've really been convicted of going to prison was like 1990. And after that it was just like technical violation on CRD, no other charges or anything.
CRD being conditional
Yeah,
release.
conditional release.
Are you asking the court to reinstate your probation?
I would like to ask the court if that, if it's submitted. I think,
Do you feel as though if you were able to be reinstated that you'd be able to comply without further violation?
Yes, I would.
Do you feel as though you could stay away from drugs?
Yes, I would.
Feel as though you could report every month?
Every month.
And no new law violations?
No rule.
Anything else that you would have the court know before they impose sentence today?
I'm going to do everything in my power to abide by the laws and the rules and stuff to stay out with, help my family, which needs me very bad right now.
Nothing further from me, Your Honor.
Steve?
Yes, Your Honor. So just to begin, Mr. Alloway does score a minimum of 29.95 months. That is a presumptive prison sentence.
I've got 22.9.
Oh, 22. Did I say 29? I meant 22.95 months. Thank you, Judge. And Your Honor, that is a presumptive prison sentence for which the defendant, in order not to be sentenced to at least that, needs to show reasons for a downward departure. Your Honor, the violation report, which has been filed with the court, and I hope the court has the benefit of looking at, states that on March the 1st, he checked in and he was told that his next probation appointment was on April the 3rd. On March 15th, he was called in for a random urinalysis, which was a presumptive positive and was sent off to the lab. He failed to report on April 3rd and was contacted by Officer Rose on April the 11th and instructed to come in. At which point, he told Officer Rose that he would be there in 30 minutes. Nevertheless, the defendant failed to report, and as of the filing of Officer Rose's violation report on April the 20th, he had not reported. So there is a failure to report, a failure to comply with his officer's instructions, and a positive drug test for cocaine. Your Honor, Mr. Alloway has on his violation report, it looks like he's been on probation, from what I can tell, at least 3 times in his life. Once in the late 1980s, once again in about 2011, and then once again maybe around 2019 or 2020. His criminal history goes back to the 1980s and includes multiple cell manufactured delivers. One of them is for cell manufactured delivered cocaine within 1,000 feet of a school, a place of worship, or a playground. Failures to appears, and one possession of a controlled substance and some other miscellaneous misdemeanor cases. Your Honor, the state's position is that he was given a second chance, getting a downward departure the first time and being placed on probation for this failure to register as a career offender because of the nonviolent nature of the crime and the fact that it had been 2 or 3 years since he had been in trouble with the law prior to the failure to register as a career offender. At this point, Mr. Alloway should not be given a second chance. Someone who's been on probation more than once in their life and was given 1 month's notice for the next appointment should be able to calendar something, know what time to show up for probation, know where to show up, and know that probation has to be made a priority. So, Your Honor, the state is asking for the 22.95 months.
Before Mr. Morrow responds, which I suspect he might, what are the requirements under the statute for the designation as a career offender? It's not something that's very common in the law.
Your Honor, give me just a second.
Mr. Morrow, you don't have to comment on that, but if you, are you going to comment on some of the other
In
stuff?
speaking with Mr. Alloway, my understanding is it had something to do with his release.
So are two lawyers, or depending on the defendant, to give us a...
No, Your Honor, I want to be clear about the registry aspect. Do you mean the charge or what got him on there in the first instance? Because I didn't have anything to do with the underlying charge.
I understand, I'm just asking that, but I don't think we need to ask the defendant what the answer to my legal question.
Sure.
That's all right. I mean, if you don't know, I mean, I don't know, so it's, don't feel bad. It's not something we normally run into a lot. Why don't we just pass over that issue, and why don't you wish to reply to?
What I might suggest, Your Honor, is it's a little bit moot. We know that he is on the registry and that he needs to be on the registry. That's how we got this charge. That's how we ended up on probation.
Correct.
But my understanding was it had something to do with his conditional release and parole in this case back, in this case that we pled to in late 80s, 89, served a prison sentence from 89 to 05, and then did a little bit more time on the conditional release violation 11 to 15. But as to the case, the BOP, he's going to continue to have to register as that career offender. That will be going forward in time. If this dealing with his BOP, he'll still have that responsibility. It works honestly similar to how like the sex offender registry works. It'll have that continuing obligation, and mostly just to let them know where he is.
Okay.
I'm not sure if I answered the court's question, but
no, you didn't. I don't think you're clear about it. You think you're kind of winding your way through it. That's all right. If you don't know, just say, I don't know.
Your Honor, my understanding of this requirement is someone who has previously been designated as a habitual violent felony offender, a violent career criminal, or a 3-time violent felony offender, or as a prison, or has been sentenced as a prison releasee reoffender, and that has been released from that sanction. And this is on or after July 1st, 2002. Must thereafter register as a career offender. The information charged that as of November 2005, and he was supposed to be registering, and on October 16th he failed to register, and then on July 27th it looks like he failed to register. Or failed to register or provide a current residence or address. So I think that's how we ended up. It's a designation that's given to a person and ends up on their criminal history, and they're supposed to report every so often, just like Mr. Morrow was just stating.
Okay. I mean, the reason why I'm asking the question is that he had this designation as a career offender. It required certain registration. And the violation, which is before the court, is based upon other failures to check in, to register, comply with instructions that are similar in nature. So I just kind of wanted to make sure that I had a full understanding of what the basis is for the career offender. It's not something we run into a lot. It was basically the explanation is kind of what I intuited, but and probably what you intuited also, but we really don't want to go just based upon what we intuit. We'd rather have it based on what the law tells us.
Understood.
But anyway, so anything else you wish to reply? Could you reply to the state's issue with downward departure? Is that what you're seeking here, counsel?
I can respond to that in as much as we're not asking for a downward departure. We're asking the court to consider reinstating, which would not require.
Okay, so you're asking, so basically the court has the option either to reinstate, which would mean no prison term or no incarcerative term, or to reject your effort to reinstate, which would mandate the minimum. That's my two options, right?
I think I agree with that, Your Honor.
And my legal analysis.
I think I understand the court's clarification. So a modification does not require the score sheet's guidelines. If the court did not modify or reinstate, yes, it would be, if it was revoke and terminate supervision, it would require a guideline sentence and a downward departure to not do the 22 months.
Right. Which is not being done.
Yes, Judge, I believe if the court is revoking supervision, that's when the guidelines. Otherwise, if they're modifying it, then they would not.
That's my understanding.
For record,
you were arguing on downward departure, and I was pretty sure because Mr. Morrow regularly does not argue for downward departure because it's much easier to reinstate and better result for his clients.
Well, candidly, I don't always have grounds to ask for
you're 100%. I don't fault you for making any legal argument you can.
As to probation reinstatement, just since we seem like we're building records, probation, the statute that governs probation clearly allows the court discretion to reinstate, modify, or continue probation. For the record. Your Honor, it's the position of the defense that Mr. Alloway is still a candidate for supervision. We're asking that the court consider reinstating him to allow work this DCF case plan. He does have employment to get back to if the court would be willing to do that. He does have transportation to get to and fro. He does have a place to stay. We do have this violation, Your Honor. It is, in a way, a violation on a violation. But what I might suggest to the court is if we look closely at that criminal history, what we're seeing now is nothing like what we're seeing from Mr. Alloway in the early, late 80s, early 90s. And I would suggest to the court that despite the violation of the career offender registry, despite the violation of his probation that subsequently did, I think he still made progress, and I think he's still a candidate for supervision, Your Honor.
How old is the child that was removed from your wife?
March 2nd.
Was it a baby?
Yes.
Anything else from the state? Anything else from the defense first? Anything else?
Nothing for me, Your Honor.
State?
Nothing else from the state.
Okay, so as the court analyzed the options that it has, either to reinstate or to sentence on the minimum guidelines, although the court does have discretion to reinstate, the court does not believe that that would be appropriate. This is just a continuation of prior issues, and I think the court is well within its discretion not to reinstate. I don't believe that would be appropriate. As a result, the court is required to sentence based on the minimum standards, minimum guidelines in the score sheet of 22.95. Defendant will get credit for all time served. And one other thing that may give you some solace, and the fact that the removal was because the child, a couple things. Fortunately, I've had more experience than the average bear in child removals in my career. And the removal based upon the positive of cocaine is based upon both parents' usage of cocaine, which is what got us here. However, when the father is incarcerated, if it's not for a lengthy period of time, which this is not for a lengthy period of time, you will have an opportunity to be able to reunite with your child if you can overcome this scourge of addiction, which we're all fighting. And I mean that in all sincerity. A lot of people are fighting, a lot of people are coming forward. So you will have an opportunity to work your case plan. You don't have to get out to work your case plan. You may have to wait until you get out of prison. But you will be able to work your case plan. So, is anything else we need to do at this time? Standard court costs and fees?
Be a $100 fee, $150 cost of defense, Your Honor.
Your Honor, that revoke and terminate probation, correct?
Yes, we are revoking and terminating supervision.
Does the court need a copy of the score sheet? I have.
Yes.
How much time after release for payment? If you,
We'll just go to lien, or
Would the clerk be willing to reduce to a lien 1 year after his release from DOC?
state?
I think that's fine,
Okay. You can just approach counsel.
Yes, sir. I also have another score sheet for Mr. Bryce. I can bring that one.
What's the other score sheet?
This one,
Basically, usually Mr. out of probation. We got to put it in May.
All right.
Mr. R. John R.
Ryan Morrow for Mr. R, Your Honor. This is 21 CF 1037. We're before the court for sentencing the day after having him plead straight in court.
Very good. You wish to make an opening remark?
Very briefly, Your Honor, similar to the memo that I filed, I would say that we're asking the court to consider reinstating probation based on some testimony they'll take from Mr. R and just the nature of the violation.
State? Any opening remarks?
No, Your Honor.
Thank you. Counsel, you wish to call a witness?
I would like to call Mr. R himself.
Sir, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
I did.
All right, sir, would you state your name, please, spell your last name for the record?
John Edward R. A.R.D.
And you're here today to receive a sentence from a judge after admitting your violation of probation. You understand that, right? So, initially, I want to talk about the violation itself. I'm just going to go down. We've talked about this a lot at the county jail, but I want the court to know everything we've discussed. So, we're primarily here, as you understand, for items that were found in what the report refers to as a no-notice search of the residence, correct?
Yes.
Now, let me ask you this. Was it actually a no-notice search?
Well, I didn't know that they were coming that month, and it was the end of the month, so I was expecting them on that day or maybe the next.
So to an extent, you did know that they were coming. It wasn't so much a no-notice search. You kind of had an idea that they were going to come.
That's correct.
You didn't know just exactly what day or what time, but you had a sense pretty close to when.
Yes.
Okay. And before we get into item by item, is it fair to assume that anything that you were known that you weren't supposed to have, you would have gotten rid of it before that search occurred, fair to say? Okay, so I want to go down just one at a time. The first thing on this affidavit is compound bows with arrows. Can you talk to the court about these compound bows and arrows? Go ahead and explain to the court why those were there.
My daughters and I
frequently shot bows recreationally. And I was in the process of trying to sell mags to raise money to pay for the treatment fees.
Sure, but not so much because you didn't think you were supposed to have it.
No, I did not even consider using them as weapons or anything like that. It was just shot recreation.
It was sporting goods as
Yes.
far as you were concerned.
Absolutely.
Okay. Anything else that you would say about the bows? It's something that you and your daughter do together, yes?
Yes, my daughters and I all
Okay.
shoot together.
Number 2 is a single round of ammunition that was found in the residence. Can you tell the court about that?
The only thing I could think is that when I was cleaning all of my ammo out of my drawers, that I missed one, or maybe one fell behind the drawer or something that I didn't see, but I thought I'd gotten rid of all of them.
Okay.
I had no intention of keeping any.
So at one time, around the time of entry of the plea or after, you did have firearms and ammunition in your home, correct?
At one time, yes.
And as far as you knew, all of those items had been removed?
Yes, sir.
Okay. And you did not know that that was there?
Absolutely not.
Okay. But despite that, we've made the decision to admit this as a violation as opposed to challenge the case, correct?
Yes.
Okay. Number 3 is folding knives. Can you talk to the court about the folding knives that were found?
There was, if I'm not mistaken, there was a bone saw, a skinning knife for hunting that I never.
Again, recreational goods,
Right.
in the same way that you wouldn't have thrown all the kitchen knives out of your kitchen drawer.
Right.
Fair to say? Okay. And the last thing on here is this iPod, because you, as you know, you're not supposed to have anything that can connect to the internet, correct? Is that how you were using that iPod?
Not normally, no. We would use it for music. Like when I would go pick up my daughter, she liked to listen to certain things, and I would really like to listen to it.
But you weren't using it to surf the web or anything like that, correct?
Yeah.
Okay. Did you even know that it could, or do you know that it could?
I knew that I was aware that it could, not like 5G, but like if you connect it to your home internet or something.
Sure. But as far as you knew, it was just for listening.
I generally just left it in the truck.
Okay. And that's the violation. I want to talk about just some of your personal circumstances. Are you married?
Yes.
Currently, so
Yes.
reside together?
Yes.
And who else resides with you there at your home?
My 3 daughters.
Okay. And how old are they?
11, 14, and 17.
And do all these folks that reside with you rely on you for financial support?
Yes.
Okay. And where are you currently working?
I am not currently working.
Okay. If you weren't incarcerated, how would you be working? How would you be supporting
Construction.
yourself? Construction? Any particular trade?
I can just whichever they need. I do a lot of punch out work. I do a lot of drywall finishing.
Any particular contractor or so?
No, at the moment, no.
Okay.
They're pretty easy.
Yes, sir. You're also a veteran, isn't that right?
Yes.
Tell the court a bit about your military service.
I retired after 20 years, 2 months, 10 days, honorable service.
What was your occupational specialty?
Munitions explosives.
Okay, you did that the whole time?
Yes.
What was your rank upon your retirement?
E6.
E6. What branch, I'm sorry?
Air Force.
Air Force, all right. Honorably discharged?
Yes.
Received your retirement?
Yes.
Any deployments?
Many.
Many? How many?
Over a dozen, I would say.
Over a
I
dozen?
don't know exactly.
Sure. At least a dozen, around a dozen deployments. Any particular campaigns or tours?
Desert Shield, Desert Storm, Iraqi Freedom, Operation Comfort, Operation Provide Promise. There's a bunch of small ones.
Sure.
I can't remember all of them.
I understand. Over the course of 20 years, I sure understand. Any special awards or citations during your service that you make the court especially aware of?
Just, I did receive a commendation medal and achievement medals, things like that. Nothing, campaign medals.
You have transportation, you do transportation currently, driver's license. Okay. Anything else that you would have the court know in impose a good sentence today before we let the judge sentence you? What are you asking the judge to do?
I would like to have the probation reinstated. I in no way was trying to pull the wool over anybody's eyes or hide anything that I had. I honestly did not believe that I was in violation. They did call me. It was about an hour before they showed up. The PO called me and let me know that they were on the way. And had I thought that it was that bad, I would have had time to toss it all, but I honestly did not believe that it was bad enough to get my probation revoked.
Now let me ask this, besides this case that got you placed on probation, have you ever been found guilty of any crime?
No.
Have you ever failed to report your probation officer?
No.
Have you ever popped positive on your analysis test?
No.
Anything further you want the judge to know?
I don't believe so.
No questions from the defense, that's it, Your Honor.
Judge, Mr. Ard, you were advised by probation that you couldn't possess, carry, or own any type of weapon, correct?
Yes, ma'am.
Okay. And you did enter a plea in this case back in August of 2022.
Yes, ma'am.
And that specifically said no internet-capable devices. You signed that, correct? And that device in your car, when it was turned on by probation, it connected to Wi-Fi in the home. Is that correct?
I believe so. I'm not sure. I wouldn't argue that.
Nothing further.
No further questions from the defense, Your Honor, just argument.
The state is following witnesses.
No, Your Honor, just argument.
Your Honor, we're asking the court to consider reinstating Mr. Ard's probation. We recognize the seriousness of the underlying charges. No one's contesting that. We recognize the seriousness of violating the probation on these target charges. No one's contesting that. And Your Honor, that's the reason why this was not presented to the court as an evidentiary hearing against willful and substantial violation, because Mr. Ard wants to admit that he messed up. We're just asking the court to give him another chance. We're asking the court to look at the totality of the circumstances, not just the alarming nature of the underlying charges. We're talking about somebody who has never been found guilty of any other crime, who served this country for 20 years in the armed services, multiple deployments, many deployments, awards and citations. He continues to collect that retirement and support his family. He's going to continue to work. We're asking the court to utilize its discretion to recognize that this particular violation is not worthy of a 5-year prison sentence. That's the position of the defense, Your Honor. We are not negating the seriousness of the underlying crime, and we are not negating the seriousness of violating the court's order. We are just asking the court to look at the totality of the circumstances, Your Honor, in that we do not have any failures to report. We do not have any positive urinalysis. We do not have Mr. Ard wielding any of these, what falls under the definition of a weapon. That's not what we have. He did possess them. We're not contesting any of that. We just want the court to recognize the entirety of the situation, Your Honor, and ask the court to consider reinstating his probation.
Thank you, Judge. Did you also have a copy of the state attorney's letter filed July 10th, as well as a copy of the score sheet?
I know.
We are asking the court to impose the 5-year suspended sentence and revoke and terminate probation in accordance with PSI recommendation. In November of 2022, I believe he pled to 10 counts of possession of child porn, 4 counts of transmission, and unlawful use of a two-way device. He was given 10 years of sex offender probation and the opportunity to remain outside in the community on supervision with a 5-year suspended sentence. Some of those counts feature children as young as 6 to 8 years old, just a few years older than the defendant's daughters. So he was given a significant break up front by the state and the court, and merely 6 months later violated his probation. And not 1, not 2, not 3, but at least 4 major ways. Most significantly, he had an iPod in his vehicle with internet capabilities. And he admitted today that he did believe that connected to Wi-Fi in his home, and he did believe that had internet capabilities. He also had the 3 folding knives, the ammunition round, and 4 bows with arrows. The score sheet currently reflects a minimum of 59.85 months Department of Corrections, with a suspended sentence of 60 months and a maximum allowable of 75 years. Significantly, he agreed to that suspended sentence, that was fair as part of a negotiated plea shortly before the violation. We don't believe at this point it's appropriate to modify or reinstate probation based on the underlying charges, how quickly he violated the nature of those violations. Certainly the point of a suspended sentence is to have that hanging over your head as incentive to follow the instructions of probation. This particular defendant, his PSI indicated he's a high school graduate. He said today he spent many years in the military. He's someone who's more than capable of following rules and conditions. Things that were given to him involved having no weapons or access to them and having no internet-capable devices. He did not follow the rules in this case, and based on the danger to the community and the nature of the violations, we asked the court to impose the 5-year suspended sentence and revoke and terminate probation.
Just by way of clarification, I know the answer, but I want to make sure that both parties argue if I'm mistaken, but the suspended sentence essentially acts as a cap.
That's correct, Judge.
So we're in much the same situation we were in the last case, in that either the court reinstates the probation straight up, or it is required to sentence at the minimum guidelines, which are almost the same as the 5-year suspended.
Right, that would be the only real difference, Your Honor.
Right. Yeah, but, right, I mean, you're
we don't have
literally less than a month difference.
Yes, Your Honor.
But I just want to make sure, first of all, we need to understand, make sure we're all, give you all an opportunity to argue the law, particularly if I'm mistaken as to the law.
I don't believe you're mistaken, Your Honor.
That's our understanding as well, Your Honor. I believe 94806-2A Florida statutes. The guidelines are only triggered if you're revoking probation.
Based on both the severity of the original charges as well as the significance of the violation, the court does find it would be inappropriate to reinstate, and as a result, the court is bound to the minimum guidelines of 59.85, which the court will order. As technically, I'm not ordering 5 years suspended, which is the max, which is 60 months, but it's virtually the same thing. The court's ordering sentence of 59.85. The defendant will get credit for all time served, obviously, and there'll be standard fees and costs as required by the statute.
Your Honor, that's revoke and terminate.
Yes, that is correct.
Court advisement of his appellate rights.
It's not plea. It's a
The collection, the money, you want to have it.
Appellate rights.
We're going to go to collection on the money, on the fees. Go to collection, we don't want to have any time 5 years.
And did Your Honor wrote a copy of the score sheet?
Sure.
May I approach?
And there's no objection on the score sheet.
No objection to the score.
May I approach, Judge?
You may. Thank you. Okay. That's the last case for the day. Thank you all very much for your.
Thank you.